government of India can be protected with the different means. Daily consumer products like bags. I have shown you this iron box is different from this. Your house may have this type of iron box or Bajaj or some company. I am having this. Bisleri bottle, Aquaguard, mini bottles names are the design is different. Brush designs are different. Comb design is different. Pencil, brush, all the designs are different. So any kind of design which we need in daily product. Also, if you are something new developing, please go for the registration of the design. Again, you can check shape, configuration, surface pattern of the bottles. This yellowish bottle is different, having surface pattern than this bluish bottle, than this greenish bottle, this color. So all the surface pattern of the bottle is also different. So please, anything if you are developing new, go for the registration of the designs. School bus bat. We know the bat, but bat with this color of make design is not there in the public. Biscuits, we know Good Day, Parle G, many more biscuits. But to attract the small kids who are below 5 years, I have making Tom and Jerry look like this biscuits. So by knowing this design, childrens will make you in this thing. I want this biscuit only. Nowadays telling the born they want. Why? Because they attract the design of their biscuits. There is a selling point. There is a business point. There is a unique point. Again, pen design, sharpener design. So any kind of design. We know the pencil. Pencil with the facing of parrot, peacock is not there. So this is a new design. So we can go for registration. This is the example of patent. Garrett A. Morgan, while passing through a road, he saw an accident between car and horse carriage. He thought, how can I prevent? It may happen today, it may again happen tomorrow, day after tomorrow. So he thought after a few years, he given the technology that is called signal. Now everyone is filing. Please don't speak. I'm getting disturbed. Mute yourself, dear participant. Host, who is hosting this, please mute them. Mute them. Again, this is small scale display designs like small business. Listen, again designs. This design, this. So anything which is different, you can go for the design registration, which is these are different designs. Again, this design. This design is developed by National Institute of Design, Ahmedabad. Can anyone say how he might have the person who has given the this design, how he got the idea to give the this type of design? Please, anyone, dear participants, don't keep mum. Please make it interactive. So how he might have got the design? How telephone, as I told you. So how someone can think of doing such type of designs? How he can think intellectually? Why can't you and me?
So I think
Anyone?
this design must would have been in the scenario just because somebody has to put lots of weight on head and plus climb on mountains or something like that.
So may I?
See, yes, ma'am. Yes.
So maybe he has seen the difficulties. Maybe he has seen the difficulties
Okay.
that the problem the women are facing.
The
So
people
for
who are
the
studying in
betterment,
the National Institute carried out the survey. Yes, yes, good, good, good. Some of you are good. So, for example, the National Institute students have carried out the search survey on the construction companies, how the people are working. They found that the people started to work after the 18 age, those who are in belongs to worker class or poor families, and they have to carry stones, sands, bricks on their head. In the age of 50, they are getting neurological disorders, many head problems, nerve problems. So how to avoid, they thought, and they came up with design. You see, we can carry how much luggage we want, but it never touched on their head. It's on shoulder based on even. So this idea comes like thinking how we can solve the problem. Now this and design. So something like that, if you have some technology also that is patent. For example, today I'm getting, we know, Parkinson's disease, car, now cancer disease, everyone knows. So allopathic treatment is there. chemotherapy is there, but somebody comes with an herbal treatment of cancer. This is a new idea. You can get patent for. So how you are thinking? Because your mind is working on cancer patient, you are thinking how much affecting it. Why can't you give another treatment which is free of side effects? So you are thinking same way. The people, the students of design who are studying, they carried the survey. They thought, how can we prevent from the neurological disorder to the people who work in the construction company? So idea comes in this way only. By sitting in the home, we cannot come the idea. So that is called intellectual property, and they have given. That's a design comes. Let us see another kind of intellectual property called trademark or brand name. Visual symbol, which may be a word, name, brand, numerical or combination of colors to indicate the source of the goods from where it comes, to distinguish from the goods of the others, or it gives the authenticity of goods. For example, Reliance, we say good company. Coca-Cola, good drinks. Mazha, good day, good biscuits. Because the name and fame, and also it advertises goods and services. Protects the innocent public from buying the goods of second-rate quality. For example, I'm having these two products from different company. If I'm using this Ponds powder, spelling is Ponds, which is a registered one, got trademark. But in second-rate quality, we get the product in big cities Pounds. We never check what exactly mark is. We will be cheated in the public. Therefore, we should know what exactly the mark is registered. What is the trademark? What is the trade name? All these are mentioned there. For example, Adidas shoes, Adidas chappals, T-shirts are in the Puma shoes. They are in the second-rate quality. If you go to Mumbai, good quality is 4,000, less even bad quality by change the spelling of that second-rate quality, 200, 300 rupees. We'll be cheating the public, so we should know what exactly mark is registered. R with N circle is a registered trademark. TM is trademark applied for yet to get the registration. Duration is 10 years. It can be renewed every 10 years subject to the usage. There are different kind of trademarks. Trade names, collective marks, certification marks, taglines, slogans, shapes like Google, Adidas, Dil Mange More, Naukri.com, then Coca-Cola. Name also bottle. Bottle is design, name is trademark. McDonald's, symbol of that. Let us see another kind of intellectual property called geographical indications. Place names used to identify the source of origin, quality, reputation, or other characteristics of products like Darjeeling tea, Kanchipuram silk sari, Nagpur oranges. Term is 10 years. It can be renewed every 10 years subject to the usage. Darjeeling tea, Makrana marble of Rajasthan, Ratlami Sev, Kanchipuram silk sari, Katputli of Rajasthan, Bagprint of Madhya Pradesh, Bengali Patachitra. All these are examples of Chia. Magai Pan, Devanelli Pomelo, Apimidi Mango, Kashmiri Saffron, Sahelicha Bihar, Kurk oranges. So these are different geographical indication of that particular area will affect. And Kashmir saffron. Kashmiri locality, cold with this. So it's affect that. Let us see another kind of intellectual property called copyright. Copyright is a bundle of right. It provides its holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60. Mass communication media people, you are most of the communications comes under the copyright, because maybe videos or writing script may be yours, so you can go for the copyright. You might have heard many singers, they are no more, but still they are getting royalty for their songs. Many authors written the book, they got copyright. They are no more, but still they are getting the royalty for that. For example, if you are writing books, novels, autobiography, stories, poems, you can go for the literary works under section 2 of the Act. If you are drawing this work, artistic work, you can go for the protection under section 2C. If you are doing dramatic work, any drama, then go for the registration for dramatic work under section 2H. Musical works under section 2P. Sound recordings under section 2XX. Cinematography films under section 2F. So any kind of work, depend upon the different category, you can go for the registration. Therefore, you might have seen many films, my dialect has been copied out, my songs, some lyrics have been copied out. All infringed questions are going in the court. Many are examples out there. So these are comes under the copyright. So how we can protect a single product with the different intellectual property rights? For example, I've taken Sony because TV is very famous. We can see and everyone is saw that TV means what. So no need to explain much. TV in the Sony TV in the year 2004 to 10 in and around that, especially with the two hoopers on the TV of this, were very famous for its clarity and sound. Therefore, the remote control mechanism, he is sitting on somewhere far and operating the TV. It's a technology, so they got patent for the technology. How it looks beautifully with the color combination, they got design registration in the government of India. Sony name in this fashion, they got trademark, and the instruction which are there in the box of TV, they got copyrighted. So single product, they are protected with the more than one IPR. Therefore, other company who involved in the manufacture of TV will not copy neither technology, nor design, nor mark, nor instruction. Therefore, they are in the market. Therefore, if you see, Sony TV is also in the market. Samsung is also in the market. Independently, they are earning their own because they cannot copy each other's technology. If they're copying, they will sue in the court and they have to claim the damages for that. Let us see what is trade secret. Trade secret is one kind of intellectual property wherein it maintains secretly, never been disclosed to others. Therefore, we don't know what is the formula of Coca-Cola, what is the formula of Maza. We don't know because they are maintaining trade secret. So I have taken the example of pizza. Everyone fond of eating that. If you taste the pizza of Domino's or Pizza Hut, the taste is different from the pizza you get in other hotels. Even we are preparing the pizza in home also, but the taste is different because they're adding Domino's is adding some trade secret which are never been disclosed to others. It will be disclosed to the people who work in the kitchen of that by non-disclosure agreement. Therefore, the people outside, once they come, they never disclose. This is called trade secret. That's why the taste is different. Mumbai pav bhaji taste is different from other pav bhaji. Shauji bhojan of Nagpur is different from other parts. So everyone is having the separate specialty. Even in your home, you can check if your mom cooks some sabji is having different taste if your sister cooks, because taste of hand is also different by adding some ingredients. Therefore, the taste is different. Therefore, big companies are maintaining trade secrets. Again, I have taken the examples of this. Hello. आहेत ते पण lecture मध्ये मी पण lecture मध्ये. So I have taken the examples of different mobiles. Samsung, Apple, Nokia, all. You check with your friends, every design is protected. Every company got patent, every got the trademark. So that Sony will not copy the technology of Samsung, Samsung will not copy the technology of Apple, Apple will not copy the technology of Vivo or some other company. So if you are also developing any device, any product in the market, please first protect, get the patent, then come in the market. Why we have to know about the IPR? Maybe some students or somebody maybe who unaware of that. What is the usefulness of this? If you are a science graduate, if you are BSc, BC or any science graduate, you can become a patent agent. Every year, our office, Central Government of India, calls for the patent agent examination. You can apply. There are two papers. One is objective, another is descriptive. You can get an, if you qualify, you'll get patent agent number from Government of India. If you're a humanity graduate or arts graduate or law graduate, you can become trademark agent or copyright law agent. If you're having knowledge of IPR, you can work in the IPR policy, IPR cell of central government, state government, companies, colleges, and institutes also. Or you can work with the NGOs who are facilitating to inventor to government of India. Again, you can work in the IPR firms. There are different IPR firms in big cities like Delhi, Gurgaon, Mumbai, Pune, Bengaluru. So you can join there also. If you are having MS in chemistry, biotechnology, microbiology, physics, or any branch of B, you can join to the government office, depend upon the advertisement of the subject, which subject advertisement you got and vacancy. You can apply and you can be government servant at the our department, our Ministry of Commerce. Thousands of scientists, faculties like teachers, students, those who are doing project can also be inventor. Means they can also do something new, but they are not doing. If they want to do project, if they want to project to get a degree, they are going to the libraries, copying the senior thesis, and mere changing the data, and they are submitting to get a degree. If you want to really innovative things, if you want to be a scientist, if you want to be an inventor, means who invent something new, then you can by simple approach. How? While carry out a research or a project, identify some problems in and around you, solve that problem, you can apply for the patent. For example, we know the paracetamol. If I consume today paracetamol in the morning 8 o'clock, it takes 6 to 8 hours to reduce my fever. Somebody who is a biotechnologist or botanist comes with a medicine that is called herbal medicine who can reduce your fever within 2 hours. There is a technological advancement. You can file the patent for that because very drastic effect. So, for example, again I told you in puja, during pujas, what we do, many flowers, many plants, everything we put dumps our material in the river or pond. Government will throw some chemicals and it affect the aquatic life of the plants and animals. But if you are developing a herbal treatment or microbiological treatment for the pond water or river water, then that's an again biological new technology you can apply for that. So something if you are doing new and that can be patentable. I have given example of the device which connect solar and electric energy, herbal shampoo. Many examples are given. So simple example also you can do. We know the alarms. Once our water tank filled, it rings the bell that water tank is filled. So why can't you develop a device which can signal to the farmer that why there is current with SMS alerts, some technology. Please don't speak. Someone is speaking. Please mute them. हो हो झालंच माझं संपूर्ण. Now, if you are developing any technology, how we can write? If any topic, as I told you, topics, the process of production of biodiesel from plant and plant products. The title. What is your objective? My object to give an alternative solution to the oil field, like this thing. Then prior art. What was there? How to produce was there? How you are doing? What is the practical work? How drawbacks you are overcoming? You have to write. Then summary of the invention you have to give. How you have performed your invention and you are producing the biodiesel and what exactly parameters you are taking to produce the biodiesel from plants. Then detailed description you have to give. Drawings if you are having. Biological materials, what you are using, you can give. Then examples. Then finally you have to claim what you want protection for that. What you want to claim. Then the claims are of different type. Independent claim and dependent claim. For example, a process of production of biodiesel from plant and plant products comprising steps of first claim. Other claims process as claimant wherein plant material is so and so. Process as claim wherein temperature maintained is 10 to 20 degree. Another the process as claimant wherein pressure maintained is this much. So all the way of writing the claims during the filing of the application. Now you came to know about the different intellectual property like patent, designs, trademark, copyright, trade secret. Now, how to file the patent application in India and who can file? Any person, natural, individual, legal, company, foreigner, anyone can file the patent application. There is no age bar limit. There is no qualification limit. Anyone, because 8th standard student can also do something better. Therefore, anyone can file the patent application. How to file? By going to the particular office, you can file, or by online facility we have given since July 2007, you can sit in the office, you can file online also. There are different jurisdiction. As you are from north, New Delhi is the office, state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, capital territory of Delhi, and the union territory of Chandigarh and Delhi are supposed to file in Delhi office. So application should be depend upon the jurisdiction you are supposed to file. What are the minimum documents required for filing? Covering letter indicating the list of documents. Application form 1, wherein detail about the applicant are supposed to mention with the name, address, applicant title, mobile number, email. Proof of right is required. In that column 9 of the form 1 is supposed to sign by the inventors who has developed the new technology. They are supposed to sign. Again, you have to mention in form 2 whether you are filing provisional application or complete. Now, what is provisional application? Provisional means as soon as idea comes to your mind, you are filing the application. For example, today I got the idea that I should produce alcohol from grapes. So I'm writing on 2 pages how I'm preparing and filing. That is called provisional. Once I'm completing my all the lab work, final product, then I'm filing. That is called complete application. You are required to file form 3. Form 3 is required whether you are filing India as well as in foreign countries. So how many countries you are filing, data filing you have to mention in form 3. Form 5 is required to declaration of the inventorship. Like paper publication, what we do, I will add my friend's name as a second name, third author, fourth author. Same way, if you want to add your friend's name in the parent application, you can use the form 5. But in paper publication, we don't have equal rights to the authors. But here, everyone will have equal authors. Therefore, please keep in mind before filing the application. Then, request for examination on form 18. Until unless you request for the examination, we never examine your application. Drawings, if any, abstract of the invention is required. Once para you have to file how you have produced that by digital, that's an abstract will be published. Then if you're filing physically, pay the fees physically in form check or DD. If you're filing online, you can pay the fees online also. The fees for individual is 1,600 and for others are 8,000 up to 30 pages of your application. If more than 10 claims, 160 per claim, and others 800 per claim. Sorry, 800 per page of application. If you are writing the claims more than 10, the per claim 320 for individual, for company 1,600. So these are the fees. 80% fee concession for all the teachings. If you are college students, college faculty, then you will get 80% fee concession in filing the patent application. For request for examination, fees is 4,000 for natural person, 20,000 for the other than that. Even people says the getting patent is very late. If you want to get early patent, you can file an expedite request for examination as per Rule 24B. Form 18 is required for that. Who can file Form 18A now? If you are choosing and filing PCT application, and in that you are choosing India as an international searching authority or international preliminary examination authority, you can. Or applicant is a startup, or as per 2019 rule, one of the applicant can be ladies, or government organization and institute can also file for the expert examination, so that you will within 1 year you can get the patent for that. Fees is for individual 8,000 and for others 60,000. Forms you can get from our website ipindia.nhc.in, and it can be downloaded and you can fill. If you want to file your application online, ipindiaonline.go.in. If you are filing the patent application, e-signature or digital signature is required to file the application. If you are filing trademark application, digital signature is required. If you are filing a design application, digital signature is required. When you are filing the copyright application, nothing is required. You have to log in and access your create your own login ID and password. Then you are directly file the copyright applications. Now, how we are giving the patent in the government of India? Once you are filing the patent application, Physically it's go for the digitization. If you're filing online, we take the data as it is, then we screen depend upon the subject matter like botany, zoology, engineering side, mechanical, electronics, civil. That is screening. Classification, we are using international patent classification system to classify that. Why we are doing all those things? Because we are having specialized examiners and we are having auto allotment system. The files which you file are automatically allotted to the examiners who are specialized in the branch. If civil application, then it goes to the civil examiner only if you are classifying correctly. Therefore, classification is a must. If you are requesting for early publication, we publish your application within 1 week or at most 1 month. Otherwise, it takes 18 months for the publications. Once it's published, anyone can file the pre-grant opposition. Anyone, any public can file pre-grant. It is known to me. It is copied from me. It is public known. Display in India. I mean, there are many grounds from A to F in the section 25(1) and 25(2). So you can file opposition on any ground. If you are requesting for the examination within 48 months from the date of filing or priority, then your application is allotted to the examiner and controller. Once it allotted to the examiner and controller, then examiner carry out the search, make the gist of objection, formal, technical, and if forward to the controller. Controller will again check, modify, delete, whatever he want to do, he can do with the objection. He prepare the final report of the objection. That is called first examination report. And controller forward it to the applicant or applicant agent, whose address is given on the service for the form 1. If all the objections are met, it will be granted. Otherwise, it will be rejected. Once it is granted, then it will be published. Within 1 year from the date of publication, any person I told here, but in post grant only the interested person can oppose the application. Now, who is the interested person? For example, Maruti Suzuki company has invented new engine for their vehicle. They got the patent. Then Hyundai company, Tata Motors, Mahindra can oppose that because they are involved in the manufacture of same motor and vehicles. Therefore, they are called person interested. Once the opposition filed, we constitute an opposition board inside the office. That is called opposition board. Three officers, one is the chairman, other two members of the board. They give the recommendation on the opposition board. Once the recommendation given by that board, the opponent's ground which we issued in the office are forwarded to the applicant. Applicant will give the reply on each ground within 2 months to the office. Again, the applicant reply forward to the opponent. Opponent again give reply on that. If applicant or opponent request a hearing or by filing form 7 by paying the fees, then we keep a hearing. We fix the hearing date across the table like court hearing. In that hearing, applicant, opponent, their agents, their lawyers will or attorneys will attend in the hearing. Each ground of the opponent are discussed with the applicant, each ground clearly, sufficiently. Then applicant will try to overcome all the grounds of opponent. If applicant overcome all the grounds of opponent, then it will be granted. Otherwise, it will be rejected. If you are granting or rejecting, we give the speaking orders so that you can challenge our orders in the higher courts. If you are granting, same day we issue the certificate of grant. This is the procedure of granting the patent. Even for filing the design applications, you require 1,000 rupees fees and 4,000 for the company. Applicant name, nationality, legal status you have to give, and 2 sets of reference sheet you required. If you're small entity or startup, you have to mention. Again, classification is good, season must. You have to classify good which chapter you are coming, like food stuff in class 1, articles class 2, travel goods 3, like that we are having classification. It is available in the online. You can check afterwards because the time given is 1 hour. Already I'm completing. So how we have to read the sheet? It's called a representative state. State of novelty, disclaimer you have to give how your new design is. I'll show you directly design application, design perspective view of my design. Total number of name of the applicant, total number of seats, 5, 2 of 5, 3 of 5 for like you have to write. This is a perspective. You have to give all the views of your design application. And we have to write it below. The novelty reside in the shape configuration of the teapot. As it's a teapot, it's look new. Therefore, they are filing the design application in the Government of India. No claim is made by virtue of this registration in respect of any mechanical or other action of mechanism whatsoever on respect of any mode of principal construction. How it is made, how it works, I am not claiming. I'm claiming that my teapot, how I am, it's looking. No claim is made by virtue of this registration to any right to exclusive use of the words, letters, numbers, or trademarks appearing in the representation. If I am using any mark, I'm not claiming for that. That you have to write where the now. This is a design application view. If you're filing like this, it's not clear use, so such type of bad quality, we never accept the such type of designs. That's a clear design you can get. What is the role of patent system? Increasement or improvement of technology. Earlier X-ray was there, we got CT scan machine. Earlier Alexander Graham telephone was there, we got the mobile phone, advanced technology of mobile phone, providing reward as an exclusive right for disclosure. If you are something doing new, disclosing in the Government of India is giving you patent, that's an reward. 20 years you can make benefit out of that. Making profit or earning royalty through putting the invention to practice. Always, if you are getting the patent, put in the market, make the money out of that, not for the file record to get an promotion. Transferring into public property after expiry of term or once patent is seized means 20 years government is giving right. So how much benefit, how much sell you want to do, you can do. How much licensing you want to do, you can get the royalty of that. After 20 years, it will be in the public domain, anyone can use. Or once you are applying for patent, you are getting the patent, but you are unable to pay the renewal fee. If you are failed to pay the renewal fee, then it will be lapsed. Then anyone can use your patent application. What to do now? Because you came to know all the intellectual property rights. You came to know what is patent, design, trademark, trade secret, and all. So don't keep quiet. Share the benefit of patent system throughout the world, school, colleges, even in public domain, wherever you get the opportunity. Utilize the resource through organized R&D activities. Capture the global market judicially. If you are developing something new technology, don't come directly in the market. First, protect with the different intellectual property like patent, design, trademark, then come in the market so that other will not copy the technology. Earn profit through the protected market. Thank you.
Thank you very much, sir. That was really very knowledgeable session, and I believe our all the participants and all the contestants must have got to know so much uh, in this session. Now, I would request all my participants, if anybody have any question that is available with us, so you can directly ask any question you have, any query regarding this. Yes, Dr.
Please
Harendra Singh. Dr. Harendra Singh, you have raised your hand. Do you have any question?
I have a question from organizer. Can I?
Yes,
yes,
please,
sir.
please
You
go
can
ahead.
proceed.
Good to go.
Actually, in your prestigious group, again, some of the participants are sending the screenshot of your feedback form. So, is it necessary or not?
Once my feedback is to is compulsion for you people, which I have said you.
Yes, it's compulsory. But actually, the screenshot of your feedback form have to send on in your prestigious group.
No, no, only you have to fill the form. It's online Google form. Mine is a Google
That's
form.
why I'm asking because most of the participants are sending again and again.
That is, we don't know, sir. We have given the Google link. You have to fill that form.
Okay, thank you so much, sir. Thank you.
Yes. Okay. Any further buddy has any question regarding IPR? I mean, this intellectual property writing. Sir, meanwhile, I had.
May I say? Sorry, sorry to disturb you.
Yes, please, please.
Sir,
Go ahead.
is prototype is required for IPR, like a design right or just other right?
Pardon me, sir.
Is the prototype? If suppose I'm going for a
So
design
others are
right,
talking, so I cannot hear you properly because everyone is talking. I'm getting confusion.
Excuse
Please
me, sir.
ask, make you others to mute.
I request all the participants, please ask a question one by one. And when sir is answering any particular one, please
Yeah,
rest
somebody
all of
asked a
you.
prototype, something like that. Prototype. What is that, please?
Yes,
Once
sir.
more, can you repeat?
Sir, for design registration for IPR.
Yes, Durgesh Verma.
Uh, who has asked the question? Is that Durgesh Sharma, sir?
I'm not getting. Please, can you, Visha, Gaur, can you explain me, please?
Yes,
Now
please.
am I audible, sir?
I
Now
request
I'm
who has
audible.
asked the question, please
Can you,
mention your name so that I can mute the rest of all. Please mention your
please,
name
can you?
and repeat your
No,
question, sir.
you can communicate to me on behalf of somebody else who is asking. No problem at all.
Sir, may I ask?
Yes, ma'am.
Hello, sir. My name is Kezia. I'm from BJMC third year. So my question is, you told about trademark. So once I was
Yes.
seeing a YouTube video, so I saw like Chandni Chowk pranthas are very famous, and they have not registered their trademark. So later on, they registered their trademark, but later on, many people have opened their shops regarding the same name. So in that case, what should we do, and how should we do?
Yeah. See, you are not registered means you are supposed to do all the processing in the court. It's not the matter of Government of India trademark registry. Therefore, Udupi hotels in Canada, same example. Other hotels name are already registered like Sun Star, something like names. But Udupi hotel is very famous for South Indian dishes. It is not registered. So you can see Udupi hotels in throughout the Karnataka, Maharashtra, Delhi, wherever you get, you will find one or two Udupi hotels. They are not registered. Now they cannot do anything. Anyone can use. Even they can claim it's I am first owner and all, but still they are not registered. And other people are also doing it.
So the thing is that we should register ourselves first before getting our
Yes.
popular, because once
That's
somebody else
that's what I
got
told you.
registered,
If you
then
are coming in the market, if you are coming in the market, please protect with a different type. That's why I've taken Sony example. Technology they got protection, name got, design got, even instruction how to operate. That got the product so that even none of the things they can copy.
okay, great. Okay. Any other participant had any question? Please go ahead.
Yeah. Hello. Before, am I audible?
Yes.
Yes, you are
May I ask you?
audible.
This is what I am asking is working prototype is required for design, right?
No, for example, if you're developing design, the working may not like how it design, you can sell it. After that, you can prepare your working one. But how your
Like,
mind is have it creating that you can give, no problem at all. Working model is not required for us.
sir, in design, we design the prototype also, we design the logo, also we design
Yeah,
the
how
brand.
it design, as I showed you teapot, like that anything if you are having in mind, you can draw it out and where
We
your
can go for the
invention
patent.
lies, where novelty lies, you can explain that page and you can file it. No need of working and all. Even
Okay.
patent also, if you are claiming dandruff composition is not yet ready. Your idea comes, you can file it. You can file it. Again, everyone is speaking. It's not good sign of that.
I request, please, at one time, only one speaker can ask question so that all of us can hear the question and the answer as well. Yes, Dr. Harinder Singh, I think, has again raised his question.
Yes,
Yes,
yes.
Dr. Harinder Singh, sir.
Sir, actually, I want to know that what is the exactly risk of IPR infringement?
See, for example, IPR infringement, for example, if you are in design case, different patent. For example, I am preparing one medicine. If somebody is claiming one of the component of my medicine, that's an infringing my patent. If process, if I'm claiming my temperature range to produce alcohol from 10 to 20, 15 degree, if you're claiming your composition in the or your process in the same range, you're infringing my claim. Then that is an all infringement all comes under the court matter. If you're infringing, they will appeal. That's different. But instrument is having high risk in the patents and all, not much in the designs and trademark.
Okay, sir. Thank you.
Okay. Okay, sir. Meanwhile, your lecture, you had mentioned that trade secrets. So, when we are preparing some fooding stuff, and at the name of trade secrets, can they mention anything, and we cannot even ask whatever we are
No, that
having?
is trade secret is not need to register at all. It is with you, your company, that is knowledge with you only until you disclose to someone else. And if you're
So,
disclosing by non-disclosure agreement, you can disclose. That is called trade secret. Never been disclosed. We don't know still many of the formulas of the products because they are maintained secretly. If you are getting the patent 20 years valid, so somebody want to continue their whole business from their son to their four sons or some coming generation, why will they will disclose? They maintain secretly.
yes, fine. Now, anybody has? Yes, Mehul, you have a question? Yes, you can ask.
Hello, sir. So actually, I in this I'm a final year biotechnology student, and I have a subject on IPR, and there are means a lot of case study which I have been studying from last 4 months. So actually, I want to know your experience on more on experience on IPR.
What experience you want? In see, I am also MSc in biotechnology, MPhil in biotechnology, PhD in biology. So what you want in IPR? Exactly topic you can ask. Now you want genetic engineering you want or fermentation
Patenting
technology you
some
want.
new file, new product.
See, in biotechnology, if you are doing something new, genetically modified one, that's an technologically you can get patent or any process in the field of biotechnology, like fermentation technology go, enzyme technology go, or production, you can get patent for that. So design your project while submitting for the degree or getting degree. You develop a new topic which is very useful and you can solve some problems is in your field. For example, we know the medicinal plants. If you are isolating some genes from that and inserting some other plants to make it more resistant of something, that is process of cloning and all. But plant as such, we are not giving patent in India. Animals as such also giving. So any process you can claim in the field of biotechnology, you can get patent for that.
I think
Excuse me,
Kezia
sir.
has a question. Kezia has raised your hand. Kezia, are you there?
Sir, it's Simon, sir.
Okay, Simon. Yes, go ahead. What's your question?
Sir, myself, Simon Rai, I am from BAJMC first year. I want to ask you, what are IPR issues? Exactly what are they?
IPR is which one? There are IPR means infringement issues in patent, design, trademark, all many dialects also in copyright. See, मेरे picture का dialogue इन्होंने copy किया है, मेरे lyrics इन्होंने. These are infringement cases still going in the court since year together, but finally they are working. So what kind of you want? You ask particularly because IPR is very vast field. Prototype is not required in the IPR. As soon as the idea get, you can file the patent application. And patent you can within 12 months you can prepare your prototype ready. Any other question in the chat
Thank
box?
you,
Anyone
sir.
can read out? Yeah.
Thank you, sir.
Thank you, ma'am. Thank you. If anyone is left out question in the chat box, please, Gaur, you can check and please ask me if anything is left out in the chat box.
Any question? Do you have? Okay, sir. May I ask one question? That how often women entrepreneurs in Asian countries benefited so far in this IPR section now?
Many are there getting benefit out of this, and those people who are filing patent who are startup MSc entrepreneur, government of India is giving free of them means 10,000. He is on behalf of government of India paying to write their patent application to the agents. Means freely whatever they inventing, they can get benefit from the government of India. 10,000 rupees per work they are paying. Government of India is paying. You can check in our website. There are some name mention of the advocates or attorneys mentioned. If you want to file patent design application, you can take the benefit of that.
Okay. One student asking, what are the outcomes of workshop on IPR? I mean, that's a very humble question. That
Yeah,
what
what
will be
is?
the out? What are the outcomes of this online workshop?
No, many people are outcome is see get they are really they are getting benefit. Many of people are doing good research. They are developing simple devices designs by this workshop only. Earlier many people are doing good work, but they don't know how to protect us. One of the fellow from Nagpur has developed a technology device which can tell you that within 10 minutes you are getting the heart attack. Another fellow from the Amravati, he has developed some new designs of the bamboo plants he is using for making some new designs of something else different products. So many people are taking benefit of this IPR online. Even IPR also same like physical, we cannot each other, but I can explain you as I am physically explaining to you, taking the simple examples like sharpener, pencil, very simple, anyone can use. So even this also is very much useful to the basics who want to know about the IPR, and really they are doing good in research and doing their projects.
So there's a kid Suhas Agwane wants to ask that can patents be required for system and process related deliverable like some special design and drafted report enable system of systems process document process management practical approach.
For what practical approach? All the patents and all. Please once more.
So Suhas Agwane has a question that can patent be acquired for system and process related to deliverable like some specially designed and drafted report templates like these all kind of
See,
stuff.
yeah. See, drafted reports and all anything new product literature works come under the copyright. Any product or process. If you are developing new design, that's under design. But any product which is for a device for conversion of solar into electric energy, or a device can which use for the fermentation technology, that's a patent. Or process of medicine, such type of comes on patent. Reports and all comes under the copyright. Another one, after the expiry of patent, there is any guidelines. Once 20 years over, anyone can use your patent. There is no guidelines to use after your patent.
Okay. Shyam Pal want to ask how IPR is relevant to media education. I mean, the students of media is
See,
there.
yeah,
So there
if
are
you are any
what are the use
media,
of IPR?
if yeah, if you are made through media, if you are taking copyright for the commercial purpose, then it's not useful. If you are taking for the students purpose, there is very useful, because any good papers, good presentation of information is very much useful to the others. So it depend upon you for what copyright is applying, for commercialization or for non-commercialized. There are two way of applying the copyright. If you are applying for the commercialization, its fees also more. If not for commercialization, it's 500 per work.
Fine. Okay. Anybody has further question? Please, you can go ahead. Okay. Dhimendra Kumar Behra wants to ask, how can we protect fake news on social media platforms for the safeguard of intellectual property rights?
Say it's social media is none of our this thing, so it is your jurisdiction. Like how you are protecting our own house by keeping the guards. For example, I am developing new technology today. I have developed a new technology, the process of making CADA, which is very useful in the Corona time. The process I disclose online, and everyone is copying, but I don't know until unless I go and watch. Somebody should inform me that your product is already selling in the Meerut area. My product is in Nagpur only, but somebody copied from me or passed the message, or how, and they are manufactured. I never come to know until I come. Therefore, how we are guarding one house, same way if you are getting patent design, you have to protect like in this fashion, so that other fellow will not copy. Once you come to know that he is copying from the date of his manufacture, you can claim the damages, so he has to pay everything for you. Therefore, they will take license before you use that.
So Ajay Kumar Mishra want to ask if any scientist decode anybody's invention and make his own based on that, how IPR can protect it?
Any
Ajay Kumar
scientist?
Mishra.
Hmm.
Ajay Kumar Mishra. Yes, sir.
Please pardon me once more. Once more.
Sir, Ajay
Any
Kumar Mishra has a question that if any scientist decode anybody's invention and make his own based on that, how IPR can protect it?
see, once you are filing patent application, you are stealing from someone else or copying or decoding. We don't know at all. Once the application come to us, whoever filed the first, we are granting to them. Then you are having chance to come in the opposition that he is copied from me. Then you can come in the pre-grant and post-grant application. But before that, we are not knowing that you are copying from this or not. So your chance is to you have to come in the post grant, then we can take on the record, then we can fight. They have to prove it is mine, it is copied from me. Then we can think of that.
I think somebody is unmuted. Fine. Does anybody have any question? Further question? Well, I think that's all for today, sir, because no
Okay,
more
thank you so
conversation is
much.
here. Thank
Thank
you
you.
very much, sir, for your very precious time, and that was really useful for me, for all the participants, and all the faculties who are already connected with this program. And I will also like to thank our colleagues, Dr. Prithvi Sangha, who is very much the backhand support for this, and Dr. Vivek Singh, Nishan Sagar sir, Sachin Goswami sir, our HOD sir, Dr. Vishal Sharma, our Dean sir, Dr. Subhashan Thaledi, and I would like to invite Dr. Subhashan Thaledi sir for vote of thanks. Dr. Subhash sir, are you there?
Yes, I am very much here.
Sir, please go ahead, sir.
Okay, vote of thanks.
Yes, sir.
Thank you. Thank you, Dr. Bharatan Suryavanshi sir. It
Thank you,
was
sir.
a
Thank you so much.
knowledgeable session. And I am very, very thankful to Rajiv Gandhi National Institute of Intellectual Property Management to give us such opportunity to organize a workshop with collaboration of you. I am very, very really thankful to you and your organization. On behalf of IIMT University, Meerut, and its Chancellor Sir, Yogesh Mohan Gupta ji, Pro Chancellor Sir, Dr. Mayank Agrawal ji, Vice Chancellor Madam, Dr. Deepa Sharma, Pro Vice Chancellor Sir, Dr. Satish Bansal ji. I am really, on behalf of them, I am giving you very, very I am grateful to you for giving up this opportunity. And I am also grateful to all of participants. Those are connected with us from all across the country. And it is really a pleasing thing that today we have more than 100 participants, and those are connected with us. It's a very good sign. And this intellectual property is a very relevant subject for today's for anyone. So we should be aware, and we should create this awareness about intellectual property, copyrights, patent, all the things. And especially we have to aware the village people where rural technology is, they are inventing rural technology, but they are unaware how to get it patent, how to get it registered. So we have, being a media student and media scholar, it is our duty to uh, to spread this awareness among the people. I am again thankful to you all, and I shall be grateful to you, especially Dr. Bharat sir. Your session was very, very informative, knowledgeable, and quite interactive. I am personally thankful to you. Thank you.
Thank you, Dean sir. And again, I repeat all my participants and of course, Dr. sir, for this very useful information. And again, I request all my participants that we have shared the feedback form. Please do fill it, because that is going to help us, because this is 6-day online workshop and today is just first day. 5 more days are there, 5 more useful sessions are there. So please stay connected in these programs also. And today's session ends here. Thank you very much for joining us.
Before closing it, I would like to request to all my participants, please, whenever you are connecting with this workshop, it is my humble request to mute your audio, video. Whenever you want to ask your question, you can on it. But rest of time, today, have you seen that Bharat sir raised so many times and stopped because he get disturbed. So my request is that whenever you are online, you please follow the rules and patiently you take participate in this workshop. Thank you.
Thank you, sir. And thank you, Dr. Bharat, sir, for this useful information. And I again request all my participants to please join us tomorrow again in another session. Thank you very much.